Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is the Cautionary Tales topic. And on these Cautionary Tales episodes, we normally talk about real life cases, real life clients that are things me or my office have worked on. Or they are things that I think are just generally good things to be aware of so that you, my friend, do not turn into a cautionary tale on this podcast one day. Well, today we are going to be talking about a case, a client, which is honestly a perfect example of two things. First, it's an example of not waiting until the absolute 11th hour to do an estate plan. And second, it's an example of what us, and when I say us, I mean estate and elder law attorneys, have to weigh and analyze to see if someone has the mental capacity to sign estate planning documents. Unfortunately for us, there is no super pretty bright line rule. Like, no such rule exists that says, for example, if someone has dementia, they cannot sign an estate plan. Let me repeat that. That rule does not exist. In fact, sometimes the person who has been diagnosed with dementia have moments where they are actually quite lucid, and in those moments could sign estate documents. So that's what I mean, that there's no bright line rule. There are laws and guidelines for us, but honestly, they're fairly vague and pretty subjective. So let's talk about what happened first, as in the story, and then we'll get into what when is it too late to sign documents kind of thing afterwards. Let's name the client Tom. So Tom's son and daughter-in-law reached out to my office and basically were pleading for help. Tom had no estate plan at all, and Tom's health started to, quickly decline. Every day, we got a phone call from Tom's son or daughter in law with something else that had happened to Tom and gone wrong. And at one point, we had talked to them about trying to get a trust in place so that we could attempt to get Medicaid benefits for his likely long term care stay that was honestly inevitable. Then things changed. Tom's condition worsened, and next thing we know, he's in the hospital. So we had to schedule one of the attorneys in my office to go to the hospital to get some basic documents signed. So when I say basic documents, think like a last will and testament. Our thought was, if crap really hits the fan, at least we will have that in place. So that day comes and our attorney goes to the hospital. She finds out that the hospital has moved him. The family didn't even know yet. That's how quickly things were moving with this case. And the hospital had moved him because he had a massive internal bleed. The attorney finally gets to the right room and asks the nurse about his condition. Well, the nurse said that he's probably really, didn't know what was going on, and not to mention he has absolutely no strength. Like, he probably wouldn't even be able to hold a pen to sign. Our attorney, in effort to kind of confirm what the nurse had said, went into the room, attempted to talk to Tom, and discovered Tom was not aware of what was going on at all. He did not understand who the attorney was, why she was there, etc. And like the nurse said, Tom could barely keep his eyes open. So the likelihood of holding a pen and signing was becoming less and less likely. Actually, completely unlikely, if I'm being honest. So the attorney stepped out of the room and actually gave me a call. And she wanted to sort of bounce the situation off just another attorney, just to make sure, my brain agreed with where her brain was at. Of course I agreed. After she explained what the nurse had said and what she herself had experienced, it was clear to me that Tom was in no condition to sign those documents. So the attorney departed the hospital and informed Tom's son and daughter-in-law. Thankfully, they understood. And that's sort of where the story ends, at least for now. And I say it like that because this cautionary tale story actually happened pretty recently. So I am not sure if we'll hear that he's gotten better and maybe we can talk about signing again, or if we'll hear that he's declined even worse and maybe passed away. Though I think the possibility of maybe signing in the future if he does get better is a really good transition to what I want to talk about is really the second part, the meaty part of this episode, which is how does someone like me, an estate and elder law attorney, determine if someone has the capacity to sign estate documents like a last will and testament? Like I mentioned earlier, this is a really big area, which really stinks for me. I think a lot of people think that, say someone has been diagnosed with dementia, that they cannot sign. And like I said, that is not true. As many of us know, dementia comes in different stages. So think if someone is in like the really early stage, they very well may have capacity to sign estate planning documents. So, what is the standard? What is the standard to signing a document like a last will and testament? I kind of feel like I'm about to answer a bar exam question, to be honest. So, for a will to be considered valid, the person creating the will must have two things. Something first called testamentary intent, and second, testamentary capacity. Actually, I say that, but yes, it has to have these two things, but it also has to have like formality requirements too, like a will, depending on state requirements and state statutes. Sometimes they require, witness signatures, sometimes they require notaries, etc. People think wills require notarization in Indiana. I say that because I'm here in Indiana and they technically don't, but every state has different rules. Nonetheless, they minimally often need two unbiased witness signatures. Anyway, coming back out of that rabbit hole. So these two things, testamentary intent and testamentary capacity, are commonly shoved in one big overarching requirement, but technically they are two very separate things, guys. First, testamentary intent means that you, who is creating the will, must first be of sound mind, who is intending to make the will, and second, be free of fraud and undue influence. Now, that latter thing basically means that there's no funny business going on. Like no one has like a gun to your head to sign the thing. No one's pressured you into signing, etc. Now, second, testamentary capacity means that you, the creator of the will, has sufficient mental capacity. So what in the world does that mean, right? Well, I can promise you that the bar exam loves to test on this subject because it's such an old school rule on how you test to see if someone has testamentary capacity. So, what the rules say is to test if someone has sufficient mental capacity, you must first know the extent and value of your property. Second, know the persons who are, quote, the natural objects of your bounty. Second, you are capable of retaining the facts necessary to direct the making of a will. And fourth, you understand the nature of the act that you're about to perform. So that's like the fancy like bar exam language that they want you to be able to, like people like me to be able to spew out. But I'm sure you're thinking, what in the heck does that actually mean, Jenny? So let's talk about it. In normal people language, it basically means that you have to know or generally understand your assets, not to the penny, guys, but be able to say, generally speaking, some of your assets. You also have to know and generally understand the people around you, like who they are and how they treat you. And that the purpose of the will is to take place after you pass away on the assets that you know of and to who you want them to go to. Now, that sounds like a lot, but to me, that's my opinion is that it's a fairly low threshold. I actually, in preparation for this episode, pulled my old bar exam outlines and notes. And in the outlines, they even say that there's a general presumption that you, the creator of the will, is sane. So for someone to say that you do not have the capacity to make the will, That's on the person to prove that that you did not have capacity. A little fun fact in my outline, by the way, it actually says, do not be misled by someone that is eccentric. It's very difficult to win a lack of capacity argument absent concrete evidence. So, if I anchor back to my story here, Tom, I don't think Tom had the intent or the capacity, right? He would have been effectively unable to overcome both of the hurdles, I think, to show that he had both intent and capacity. He was more of a physical incapacity, like he couldn't really voice his wishes, voice his goals. So, would we have been able to tell if he had intent or capacity? You know, it's tough. I tend to decline and say, no. Compare Tom to someone who has dementia. So, like I said earlier, it's possible that someone with an actual diagnosis of a cognitive impairment could overcome those hurdles of testamentary intent and testamentary capacity. Honestly, I've helped several clients who have been diagnosed with some type of mental incapacity, but they are in the early stages and they could very much express their intent and they could easily overcome the capacity test. Unfortunately, in my world, this is a very litigated subject, which I'm sure you could see why. It's so subjective, right? Is it, in my opinion, okay for this person to sign? Keep in mind, I am not a medical doctor. I know the legal threshold of creating a will. And medical doctors would know the medical aspect, obviously. So there are probably plenty of cases out there where the attorney thought it was, appropriate to have a person sign a will, but the doctor would say that the person struggles or cannot make legal and financial decisions. That could become directly in conflict with one another. You see what I mean? So, like I've talked about before on here, our legal system, is not exactly set up very well to handle, disputed cases. So often cases get settled because it becomes economically and financially inefficient to keep fighting. So parties end up settling, and otherwise, if they don't, they could potentially get upside down. Meaning, if they're fighting over mom's estate that is worth $300,000, for example, and their legal fees continue to increase and accrue, at what point is it truly not worth it anymore? And maybe besides emotionally and, to quote, make a point. That's why estate litigation attorneys exist, to navigate these waters. One way to deter disputes like this is to encourage whoever is creating the will to document. And some attorneys have even developed a form for a doctor to complete that will specifically ask them questions to gauge whether someone has the appropriate capacity to sign. So instead of just simply, to the doctor saying, or from the doctor saying, oh, they have dementia and shouldn't be making legal and financial decisions, instead, they complete this form, which is asking them questions to support or not the test to determine if someone has capacity to sign. So instead of asking the doctor more technical medical questions, it's more kind of fluffy questions in a way about what does this person know and understand, etc. I'm not sure if that makes sense, but nonetheless, I actually had a client recently that was disinheriting a child. And she was really concerned her child would say that she was, off her rocker. Well, to deter that argument, she went to her doctor and had the doctor complete a similar form that I just discussed. And so consider that idea. If you're ever concerned about someone kicking up a fuss about, your capacity to sign a will, just remember that story. Kind of interesting, huh? Alrighty, let's shift to a sneak peek of next week, which we are circling back to the current trends topic, where we talk about things that are going on currently that impact my estate and elder law world. Or maybe they're things I've stumbled across on the news or social media that are relevant to this podcast. Well, next week, I'm going to dive into something called deed theft or title theft that you may or may not have heard of, or maybe you've seen it on TV. I'm just getting asked more and more about it. So let's talk about it. And we're going to talk about that next time, Legal Tea listeners. So until then, be well and talk soon.